And it's now 11 o'clock, so we will go ahead and get started. Welcome everybody to our webinar today about navigating current fair housing complexities. We have a great program lined up for you, and I'm sure more folks will be joining as we get things kicked off. This program was put together by our program and seminar committee, which is led by Alice Jippelman with K Apartment Communities and Melissa Mariotti. We are always looking for input about what topics you're most interested in learning about. So if you're interested in getting involved, that is a great place to do so. Before we kick our program off, I have a few companies that we'd like to thank. Our corporate sponsors make all that we do at PMA possible, and they include, suspenseful, there we go. Our platinum sponsors include Residency Bureau, InterSolutions, and Tepfer Construction. And then for our 2023 gold sponsors, we have American Pest, Brothers Paving and Concrete, Capital Canopies, Electronic Security Services, Hawkins Electric, JB Klein Landscaping, Minkoff Company, Multi-Housing Depot, Planned Companies, and Pothole Repair. And then last but not least, we have our silver sponsors. They include Berkshire, Donaldson, Finley, Kenmore, Orndorff and Spade, PC Richard and Sons, Quest Insurance, Rain and Son, Thomasville Restoration, and TRC Engineering. And what would a PMA program be without some promotion for some upcoming events and programs? It is award season at PMA. If you haven't seen the emails, I don't know, you must not be looking very hard. We are currently soliciting nominations for all of our award programs, including the PACE Awards, Maintenance Professional Awards, Leasing Professional Awards, and EPIC Awards. And then our Marketing, Advertising, and Excellence Award nomination form is coming soon. Those entries are due within the next 30 or so days. So I encourage you to visit our website, submit your entries. We know we have a lot of phenomenal members out there doing a lot of phenomenal work, and you guys deserve recognition for that work. So please keep an eye out for those. And then in terms of our other upcoming events and programs, I have a whole list. I'm not going to read them all for you here, but some ones that are a big highlight for us. We have a webinar on quiet quitting scheduled for May 10th. We have our in-person Stephen Knowles Cleanup Day on Tuesday, May 16th. Then we have our in-person Leasing and Maintenance Summit. Our Leasing and Maintenance Summit are back. We will be at Martin's Crosswinds on Thursday, May 25th. We have Christy Fickert from RealLink talking about using video for your marketing teams, and your marketing teams will walk away with some video clips that they can use their next day in the office. And then for the maintenance teams, we have appliance training as well as HVAC training, and we'll have some inspirational speakers as well. Also, our Summer Escape is scheduled for June 26th. The registration rates for that increase at the end of this month. Our Summer Escape is a golf outing on steroids, if you will. There's something for everybody. There's a spa outing, there's a beer and wine social, so literally something for everybody at our Summer Escape. And then one more plug, our expo is coming up on Wednesday, October 25th. We will be at the Gaylord in the National Harbor. We will have Rachel Druckenmiller, who kicked us off at Activate PMA. She'll be doing the keynote address for that. So I know Candace shared a link in the chat about our calendar and our awards program. So I encourage you to visit those websites after today's webinar so you can focus today and check out everything that we have coming up. And that then brings us to our webinar today. We've tapped Jonathan Singer, who's a partner with Saul Ewing, to do our presentation today. John is a litigator and business lawyer with experience representing both publicly traded and privately held companies in a wide variety of capacities. His practice focuses on several industries, including multifamily, where he has defended owners, operators, and property managers in some of the most significant, challenging industry-wide practices. With that, I'll turn it over to John.
Thanks, Sarah. Appreciate the introduction, and I'm happy to be here with everybody this morning. So as Sarah mentioned, we are here today to talk through everybody's favorite subject, which is fair housing. I do fair housing training for companies together with a partner of mine at Beyond the Balloons. We come in and do this training fairly regularly for clients. And we have found that it is most rewarding when it is engaging and interactive. So certainly to the extent anybody has questions as we go along, feel free to either unmute yourself and just ask, say hi and ask, or shoot something in the chat box, and we will see it and address it as we go along. So I will tell you a little bit about where we're headed here. But in general, I'm starting from the understanding and expectation that most folks here have experience and some baseline understanding of the Fair Housing Act. Obviously, it's paramount in everything that we do in the multifamily industry. So I will spend a little bit of time sort of going back through some basics on it, but the bulk of this session is going to be focused on current developments, what's happening, what cases we're seeing, what federal agencies are saying about what they're going to do with issues that will ultimately implicate fair housing. So as I said, also, if anybody has questions, thoughts, comments as we go along, feel free to jump in. So with that, we'll turn to the slides. And as I mentioned, everybody's probably aware the Fair Housing Act was implemented back in the 60s to protect individuals from discrimination when they're renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. For this group, we're looking at renting, obviously, for the most part. And the types of housing that is covered, it's going to cover all of the organizations, all the companies that are part of PMA, I suspect. But I always get this question, so I include a slide on it. Yes, there are several exemptions for it, for buildings with no more than 4 units, single-family households rented by the owners, and religious and private clubs under certain exceptions. For the vast majority of people in the property management industry, these exemptions have no real effect, and we are all subject to fair housing, and something we need to be mindful of as we operate our properties. Who is protected under the Fair Housing Act? The categories of protected classes include race, color, national origin, religion, sex, familial status, and disability. As you see on the slide, the sex category was expanded in 2021 to include gender identity and sexual orientation, which was not previously a protected class. At least not expressly under the FHA. As you'll see as we're going through this, with those additions in 2021, HUD and other federal agencies are paying particular attention to that protected class through various enforcement actions that they're bringing in courts and in administrative proceedings to sort of tell the world that, hey, as a reminder, we brought in the category of protected class based on sex, so be mindful of what's happening here, and we'll talk more about that as we go through. Also important to remember when we're talking FHA, there are 2 types of discrimination really that can exist under the FHA and in general, but particularly under the FHA. One is facially improper policies, rules, regulations that result in disparate treatment of individuals based on their protected class. Having a policy in place that overtly discriminates against minorities or women or sexual preferences, things like that are going to be the disparate treatment category of discrimination. What we see more often and what is more challenging for property managers and property owners is the disparate impact. And that is where a company has a facially neutral policy that does not discriminate against any protected class or unprotected class for that matter. But the application of this facially neutral policy for one reason or another ends up disproportionately impacting individuals within a protected class. And that's considered a disparate impact type of discrimination. And that is what I find that property owners and management companies need to be most mindful of in implementing, developing, and ultimately enforcing various policies throughout their properties. So we'll see some examples of that as well. There is a lot that's prohibited in the sale of rent or rental of housing under the FHA. I identified several of the examples that are up on HUD's website. These are basic things that everybody's aware of generally, and usually has policies that make clear, hey, we're cognizant of the FHA. We're an equal housing opportunity provider. We don't discriminate on the basis of race, sex, gender, national origin, etc. Yet there are still times where, despite disclosing that, entities find themselves with a policy that either unintentionally on its face engages in some sort of, or approaches some sort of discriminatory behavior, or, as I said, results in a disparate impact. So some of these examples include setting different terms, conditions, or privileges for the sale of or rental of a dwelling unit, using different qualification criteria, making, printing, or publishing any notice, statement, or advertisement that indicates any preference, limitation, or discrimination. Advertising, I want to pause there. Advertising is one that some companies are really good about being intentional and mindful in their advertising. Either we're not going to put pictures up at all because we don't want anybody to say we're discriminating against this type of person or that person by not including them in the photos. Others are very good about making sure that any sort of imagery or advertising used is really inclusive and really prohibits somebody from suggesting that they are either discriminating based on disparate treatment, or inadvertently discriminating in advertising by focusing on or suggesting that certain groups would be ideal renters in their properties, and therefore inadvertently having a disparate impact in their advertising. So advertising is something we're always paying close attention to. Additionally, and you'll see some examples of this one later on, limiting privileges, services, or facilities at a property can have disparate impacts, can disproportionately impact certain protected classes, as you'll see when we get to familial status a little bit later. Failing or delaying performance of maintenance or repairs, assigning a person to a particular section of a building or neighborhood, whether based on pets, whether based on having children and familial status, smoking, things like that, can all be used to raise a claim of disparate treatment or impact under the FHA. Not always going to be a viable claim, but as I always tell my clients, even if a claim is asserted, even if it's not viable, it still obviously has a major impact on the business. Sometimes it's a cost of doing business to deal with some meritless claims, but we try to deal with these things on the front end to try to minimize the likelihood that claims are going to be brought in the first place, because even when you're successful, there's an interference to the business, an interruption, and obviously cost to all of that. So here's a little bit of a roadmap of what we're going to do today. Because fair housing is such a major issue in the industry, and a training that I find that companies routinely provide to their staff and their employees, I want to focus on some bigger picture issues related to fair housing and give some context for why fair housing's actually more important in some ways today than it has been in recent years. Of course, it's of paramount importance in the industry, but with the change in the administration and some recent guidances that have been put out, it's clear sort of where the focus is going to be at the federal level and what sort of risks the industry is facing from an exposure standpoint, and some thoughts about how the industry can develop and implement policies to sort of mitigate against these clear and obvious risks that we're seeing signs of. So we're going to talk through the White House blueprint for a renter's Bill of Rights that was put out earlier this year. We'll talk briefly about the Consumer Financial Protection Bureaus and Federal Trade Commission's late February request for information on background screening. We'll talk about the HUD Secretary's recent memo just back in March on junk fees and tenant screening. And then we'll get into some background screening, sexual orientation, gender identity discrimination, emotional support service animals, familial status, and marijuana related issues as things that I frequently get questions about. So starting with the White House Renters Bill of Rights. This was a white paper that the White House Domestic Policy Council and National Economic Council put out earlier this year. And as you'll see, if you click on any of those links below, and I haven't talked with Sarah about whether or not we're sharing the slides or how that works after, but certainly be happy to if that's permissible through PMA and if anybody would like them. But if you clicked on any of these links below, you'll see that the White House Renters Bill of Rights is intended to support the development of policies and practices that promote fairness for Americans living in rental housing. And what the blueprint does is it sets forth a set of principles that are really going to drive what the federal government's going to do under the new administration, which will trickle down to state and local governments and agencies as well. And ultimately, the hope is, from their perspective, into the private sector to really strengthen tenant protections and encourage rental affordability. I know that that is sometimes at odds with how we operate within the industry. Of course, nobody's overtly trying to undertake any policies that adversely affect tenants, but at the same time, my clients and you all here have businesses to run, and it's important that you're able to do that, but it is necessary in doing so to sort of understand what the perspective is at the federal level right now. So as I mentioned, there's several principles that we can distill from this blueprint for a Renters Bill of Rights. I bolded two of them because we're going to talk more about them, but there's safe, quality, accessible, and affordable housing, emphasis on accessible housing in there for our purposes today. Clear and fair leases, which we're not going to talk too much about, but in general, that's dealing with lease disclosures, making sure tenants are aware of what they're signing up for in a nutshell. Education, enforcement, and enhancement of renters' rights. We're going to talk a lot about that today, the enforcement piece in particular, and what we're seeing over the last couple of years that this blueprint for a Renters Bill of Rights is expanding upon. The right to organize, which deals with the right to have tenant associations like unions. Not going to talk about that here today, but that's an important aspect of the Bill of Rights that we can talk about offline if anybody has questions. Eviction prevention, diversion, and relief, same thing. Not going to talk too much about that today. Obviously, that's something the entire industry is always paying attention to. Happy to talk more about that offline. I pulled out a few snippets from this 25-page or 23-page or so Renters Bill of Rights that the White House Policy Council put out in January, just because I think it's helpful to contextualize what I'm saying here. So among them, they state that in addition to underpinning the policy actions that the administration is announcing, the principles will guide future federal policies and programs and updates to rulemaking guidance and notices governing existing policies and programs. What they're telling us is this Bill of Rights is critical for what the federal agencies are going to be doing as they hone in on really consumer-facing organizations altogether, with the multifamily and housing industry being one of the most prominent industries that they're looking at, in addition to consumer financing as well. They speak in there about accessible housing in particular. They reference a statement from the FTC where they announced that the FTC, who has not historically gotten too terribly involved in rental housing, is now going to be looking at the FTC Act to figure out what authority it has under that act as that agency to start taking a look at acts and practices that are inhibiting consumers from fairly obtaining and retaining rental housing. That is something that we're paying close attention to because, as everybody here is probably aware, we've historically looked at HUD primarily as the enforcement arm as relates to the FHA and other federal statutes governing the industry. But as you'll see, there's sort of a whole of government effort that is part of this blueprint for a Renters Bill of Rights that is going to implicate a number of federal agencies that are going to start taking a look at what we're doing here in the multifamily industry. FTC also indicated that they're going to put out this RFI, request for information, with the Consumer Financial Protection Bureau excuse the typo in there, to obtain data to assist in identifying these practices and harms that housing applicants undergo during the application process. We're going to talk about that RFI that came out at the end of February. And then so we've got FTC, we've got CFPB, and on this slide we've got HUD, who's commenting as part of the blueprint for a renter's bill of rights. So you can already see the unification among the federal agencies as to what they are going to be doing here to implement the core principles of this renter's bill of rights. And HUD focused in particular on accessibility standards for HUD-assisted facilities, but this is going to trickle into privately owned facilities as well. And they're paying particular attention to how rental housing providers are dealing with individuals with disabilities to make sure that they have equal access, not just to HUD-assisted programs as was commented on in here, but also to all programs at privately owned properties as well. Moving on to the enforcement and enhancement section of this blueprint for a renter's bill of rights. There's language in there indicating that federal, state, and local governments are going to ensure that renters know their existing legal rights and protect them from unlawful discrimination. One of the things that they talk about in here is disclosure to tenants in ways that are broader than what the industry has historically done, in terms of not just providing an adverse action letter when someone is denied, but giving a little bit more detail into the why of the denial, particularly when it comes to background checks. And we'll talk about this as well later, about the intersection of criminal background checks and the FHA. So we'll deal with that in a little bit. And you see that in the Renter's Bill of Rights, they dealt specifically with the Fair Housing Act to state that government bodies at all levels are going to be ensuring that rights and protections under the FHA and other federal laws are known and enforced. And this is a theme that's important to drill home, and that is the disclosure to tenants of their rights under the FHA. Again, we haven't seen this yet, but I felt like it's important to stick in here, and that is the administration's look at expanding some of these FHA rights. Source of income is something that we've dealt with and seen in various jurisdictions. They've added source of income, as some of you may deal with at your properties, as a protected class in some local levels. But also they are talking about expanding rights generally within the scope of their defined protected classes. So it's something that we're paying attention to, and that the industry is paying attention to in response to this blueprint for a Renter's Bill of Rights. Sexual harassment is something that's obviously always been an issue that they've paid particular attention to, but it made it into the Renter's Bill of Rights. So it's something that we find important in the context of what these agencies are going to be focusing on over the next year, 2, 3 years. This slide is just the organization talking more about what we all know already, that exclusion in rental markets can manifest in different ways. This is more of the disparate impact type stuff, inaccurate information in tenant background checks, discriminatory, ensuring non-discriminatory background checks to ensure renters can access housing and have neighborhood choice. And this last bullet is what I mentioned earlier about housing providers informing applicants why they were denied or charge more, why they were denied, particularly in the criminal background setting, is something that they are focusing on more than they have in the past in terms of what opportunities tenants should be given to explain relevant mitigating factors to any quote unquote records found on their criminal background checks that might influence housing decisions. And the reason for all of this is based on research that they cite in the blueprint for a Renter's Bill of Rights regarding the disparate impact that a lot of housing policies have on minorities when they inquire and apply for rental housing, which, as I mentioned earlier, is not necessarily going to be the result of a disparate treatment violation or alleged violation, but more the result of a disparate impact issue. And you see here again within the blueprint, the focus on individuals with disabilities as well. So we're going to talk more about that. We will touch on this a little bit later as well, but important to flag the federal agencies are focused a great deal right now on algorithms and credit reports in background checks. That is not just in the multifamily industry, but certainly something that has made its way in to the blueprint for a renter's bill of rights, and something that the federal agencies are really looking at how companies are dealing with and processing criminal background checks, what companies are performing those criminal background checks for property owners and property managers, whether algorithms are used in that process, and ultimately what's happening as a result of that. Is it having, are those policies and practices having a disparate impact on any protected classes? In the blueprint, they're talking about minorities based on race, Blacks, Latinos, Asian households, who they state are at greater risk of error in these reports. And I've got a slide on this later on, but it's relevant here. In general, criminal background checks are not, and people with convictions are not a protected class under the FHA, as you saw on the slide earlier. But the effect of running those checks obviously can have significant effects on protected classes based on race, gender, things like that. And as a result of that, can sort of backdoor in and give rise to the risk of a disparate impact discrimination claim under the FHA. So that's sort of where the intersection occurs. They'll sort of getting to the end of the slide on the blueprint, or the end of the information on the blueprint. They sort of finished it up by mentioning that HUD, FHA, FA, FTC, and USDA, the Department of Agriculture, have said they're going to work with CFPB. And you can see just in that line right there, 5 different federal agencies that are looking at best practices on the use of tenant screening reports, and including the importance of communicating to tenants the use of these background checks, how we use them, why we use them, and how decisions are made based around them. They have not issued, there are 2 memos that HUD has put out in 2016 and 2022, both of which predate this blueprint for a renter's bill of rights earlier in 2023. So we haven't seen those best practices in response to this blueprint for a renter's bill of rights yet, but the HUD guidance memos from 2016 and 2022 do set forth really a mechanism for how HUD would like to see companies processing criminal background checks, and sort of the relationship and communication channels between the applicants and the companies in terms of how decisions are going to be made, why they're made, and why a tenant is denied, and when the tenant is going to have the opportunity to provide those relevant mitigating factors in response to any criminal convictions that may show up or do show up on their background checks. So those HUD guidances have been really helpful for me and others in the industry in crafting criminal background policies that landlords and property managers and owners can hold up in the face of a discrimination charge to say, look, we're mindful of these guidances that you put out. We crafted a policy around these guidances you put out. We implemented that policy fairly and consistently across our portfolio for all of our tenants. And the fact of a denial by itself is not going to be sufficient to trigger a claim or establish a claim for a charge. But it is important within those HUD guidances that were put out in 16 and 22, and likely what will be forthcoming when these agencies actually do release these best practices, it is important to have somewhat of an interactive process with the tenant, primarily to provide yourselves the protection in the event of a charge, which nobody can stop from coming, but you want to put yourself in the best position that you can be in to defend against it if need be. And as indicated at the bottom, HUD will also release guidance addressing the use of tenant screening algorithms in ways that may violate the Fair Housing Act. That has not yet happened, but it is forthcoming. The reason why that probably hasn't yet happened is because the federal agencies that we've outlined are collaborating and putting out information requests and gathering information to assist in this process to ultimately issue more. It's not going to necessarily be binding legal authority because it's not going to take the form of statutes, but obviously when the enforcement agencies put forth guidance as to their interpretations of federal statutes and or how they intend to enforce federal statutes, it effectively is binding if we're trying to avoid claims and charges by any federal agencies or tenants. So what the CFPB and FTC put out at the end of February was a 10-page request for information, which they described as part of this whole of government effort to address a range of challenges facing renters. This RFI contained nearly 100 different questions exploring the tenant screening process generally and focused in on the use of criminal records, eviction records, and algorithms and other automated decision-making technologies in the screening process. That was not all of the RFI, but that was a big chunk of the RFI, which again telegraphs to us what these agencies are thinking about and what's going to be a focus on the enforcement side for them as they go forward and develop their plans to carry out this fairly recent, I mean, it's a 3-month-old blueprint for a renter's Bill of Rights. So that will be forthcoming. I think responses to this RFI are due at the end of May. And that will be informative to how the agencies go forward in terms of what guidance they're going to put out. We've put out some publications on this. If anybody in the industry is interested in commenting in response to this RFI, it is a public RFI. Anybody's able to do so. I don't know if PMA is taking a look at that or if that's something anybody has discussed within PMA yet. But again, something happy to talk about offline, can certainly provide this RFI to anybody who would like to see it and talk through with anybody if there are thoughts or questions about sort of what responses industry members may be considering submitting. And this is just a little bit of an example of some of the actual details within the RFI that they are searching for information about. How criminal and eviction records are used by landlords and property managers to make rental housing decisions, how these potential inaccuracies in the records affect the decisions, whether consumers are informed about the criteria used in tenant screening, such as relevant look-back periods for different convictions, what convictions we're looking for, what our look-back periods are for them, how we're going to make discretionary calls in the event of an old conviction. Obviously, we are to consider the nature, severity, timing of these various convictions. What are our policies around that? Is the policy available to the tenants if they wish to request it? Things like that are going to be paramount for the agencies as they look through this. Also looking at application and screening fees in connection with this, and we already mentioned algorithms and automated decision making and AI used in the process. So these are some of the things that are part of the RFI that are going to inform the guidance that's forthcoming. That was at the end of February. A week later, just about 6 weeks ago, HUD secretary put out a completely separate memo on junk fee, what they term junk fees and tenant screening reports. And she reiterated that HUD's going to coordinate with CFPB, FHFA, FTC, and USDA to release these best practices on tenant screening reports. And here again, including the importance of communicating whether such reports are used to reject applicants or increase fees, and providing applicants with the opportunity to address inaccurate information therein. So this feels like a lot like redundant as we go through the blueprint the FTC and CFPB, RFI, and HUD Secretary's memo. But I think that redundancy is really important, and to consider that it really drives home and instills what is going on at the federal level, and that all of these agencies, not just HUD and not just Policy Council, they are all tasked with and beginning the process of carrying out their investigation into these processes that are used throughout the industry. And what that's ultimately going to mean is enforcement actions down the line. And they're going to publicize these enforcement actions, and they're going to do so to try to get the industry to sort of fall in line with what they would like to see on a going forward basis relative to some of these policies, procedures, and practices in the industry. So now is a really good time for anybody, if any of you are involved within your companies, at taking a look at how you're doing criminal background, tenant screening, things like that in particular. Now's a really good time to be assessing that before all of this comes out and imposes new requirements that are not, that I'm seeing are not consistently carried out throughout the industry, because they haven't had to be in the same way. There hasn't been the same sort of risk of exposure that we're seeing at the beginning of this year that may be coming down the pipe. As I mentioned before, criminal history is not a protected class. Poor credit is not a protected class. But what's important about those is the ability for poor credit or criminal history based decisions to open the door to the possibility of a disparate impact discrimination claim or charge as a result of the disproportionate impact that credit screening and criminal history screening can have on protected classes. And that's what that third bullet is there. I wanted to focus, obviously we've talked a good bit about criminal screening in terms of the focus at the federal agency level. And I mentioned the HUD guidance from 2016 to 2022, but I want to focus a little bit more on that here to talk about what we're seeing and what we're doing in relation to that guidance, and what I think that all companies in the industry should be taking a look at within their own companies, and making a decision as to whether or not they need to do anything a little differently, and or whether or not they need to paper their files with a formal written policy to protect against potentially forthcoming discrimination charges. So the HUD guidance I mentioned earlier recognizes the disproportionate conviction and incarceration rates among African Americans and Hispanics relative to other United States citizens, leading to a disproportionate impact on minority home seekers. That is set forth in HUD's 2016 guidance, reiterated again in the 2022 guidance. The fact that they put out two guidances within 6 years indicates that they weren't seeing the type of movement and traction that they had been looking for during that time period, and consistent with the subsequent stuff that we've looked at in the beginning of 2023. This is going to remain a major focus for HUD and other agencies. So as I've said, we believe it's really important to have a HUD approved. When I say HUD approved policy in place, it's not actually formally approved by HUD, but the written policy acknowledges the guidance, takes into account the guidance, crafts a policy around that guidance, and therefore in the event of a charge, which this industry, obviously your guys' industry and our industry, as you're all well aware, as a consumer-facing industry, is always at risk of frivolous and or non-frivolous lawsuits just by the nature of the type of business that you all conduct. So having a policy in place that accounts for this is really going to mitigate that risk, certainly mitigate the impact of any potential charge that comes your way. So the first bullet talks about having a written policy or SOP in place. Talking about arrest versus conviction, really important. It's pretty clear that property management companies and landlords should not be discriminating or should not be making housing decisions on the basis of arrests. What HUD has said is, absent a conviction, there's not enough factual evidence to establish that the criminal conduct occurred, and therefore that it would pose a threat to what are the two classic legitimate substantial and non-discriminatory interests of protecting persons and property. An arrest is not going to be enough in HUD's eyes to establish that the conduct occurred and threatens the safety of persons or property. So they're looking for convictions, and anything short of that is going to put property managers at risk for a discrimination charge. On top of that, it's not just the convictions. Any policy that is going to say we're going to exclude somebody on the basis of a conviction, period, full stop, is going to be at real risk as well for disparate impact discrimination claims under the FHA, based on the comment at the top that there's a disproportionate conviction and incarceration rates among the protected classes that include African Americans and Hispanics. So what the policies really need to do to avoid and defend against any potential charges down the line is to take into account the nature, severity, and timing of the criminal conduct. That's having different look back periods for different convictions. Some convictions are more significant and pose greater threats than others, obviously, and that's where severity and nature comes in. Timing, are we looking at a history of convictions, multiple convictions within our look back period? How's that all going to work? That's something that property managers and landlords need to be taking into account. And then I've said it several times, but relevant mitigating factors, where is that going to come in? Are we considering facts around the conviction, their age at the time of the conviction, their subsequent history post-conviction, and perhaps post-incarceration? What rehabilitation efforts have they undergone? Do they have a 5-10 year rental housing history post-conviction that's flawless? Like, what are we doing to consider these relevant mitigating factors, and when and how are we doing it? And I know it presents a challenge, and the guidance presents a challenge, because at the same time, the guidance says we don't want property managers conducting these individualized tenant by tenant analyses and decisions, because that's where discrimination can occur. They don't want people doing that. But at the same time, they say, if your policy is otherwise going to exclude on the basis of a conviction, you need to do it. Well, that's going to be every circumstance, right? Because if a conviction comes up, the policy is going to be, we're going to exclude based on this conviction, because we set the criteria for what we're going to look for in terms of nature, severity, and timing. So if it fit those criteria, it's going to be an exclusion. But that's the circumstance where HUD has said they want property managers and landlords and owners to allow tenants the opportunity to describe relevant mitigating factors. So from my view, that's something HUD wants each time. And that's the best way to protect against a discrimination claim coming down the line. And that's something that generally can be incorporated into a policy. Certainly something that you should talk with your folks about after this and take a look at, because it is a really important issue. If you have counsel in your companies, talk to them about that. If you have outside counsel, talk to them about it. But this is an issue that I wanted to hammer home because it is really important.
John, can I jump in just a moment?
Yes, of course.
Having gone through this discrimination suit already in the last 2 years, we, as part of the settlement agreement, wound up having to really do exactly what you said and look at how we were filing or how we were looking at and judging people's criminal backgrounds. And basically, as part of the settlement agreement, the only things we're looking at are drug manufacturing, sexual crimes, homicide. Again, only arrests, not convictions, only those things within the last 5 to 7 years, with the exception of child, pedophiles. And for every person that comes back with a conviction, we are required to go back to that person and ask them what happened, what have they done to rehabilitate, so on and so forth. And it is actually a part of our application process that tells them, if they know they have a conviction, that they can submit along with their application any supporting documentation. And this was not something that we set out to do. Like you said, it was because somebody got involved with another agency that got involved with whatever, and it just took on a life of its own. And 2 years later, it was not a fun process to go through. So I really encourage people to look at and make those decisions now.
Yeah, Suzanne, thank you so much for chiming in with that. Can I ask, because we haven't met, can I ask who you're with? Because I have another client who's got an identical story. I'm curious if
K Apartment Communities.
Okay, you're with K.
Mhm.
So I've got another client who's not K, same exact circumstance, calls them to, obviously go back, redo both the lease application. They now have a disclosure on the lease application that was crafted around these issues. And then we drafted a criminal background policy that has a form letter attached to the back of it that each time there's a conviction that hits, they will automatically send this letter out that identifies the conviction, invites them, refers back to the lease application, invites them to provide relevant mitigating factors that we outline categories for them. And we're doing all of it really in response to not just the charge that happened, but in response to the HUD guidance. And you guys at K and my client elsewhere are two perfect examples, of the fact that this happened. You had to bring in counsel for it. If my client had this policy and practice in place before this happened, I'm not sure the charge ever would have happened. And either way, once it did, we would have handed over this written policy. We would have handed over the letter. We would have handed over any response we got. And, we would have said, look, this is exactly what you told us to do. We said we created a policy around what you told us to do. And I don't know what else you want from us. And I think that would have been the end. Instead, there was a consent order for them and they had to pay a little bit of a fine. They had to pay lawyers obviously longer to go through it and defend them. And then also there was, had to go back and recreate these papers. So my view on this stuff is always, nobody ever likes to call their lawyer. Nobody ever likes to call me and say, hey, I need you to do this or I need you to do that, because it costs money and we get that. But I always tell people it costs a heck of a lot less on the front end to try to get things right and get them in place than it does to deal with a problem on the back end. So I really appreciate you sharing that. Sounds like you had a similar experience.
Thank you.
I wanted to put this case in here. This is a case that's currently pending against Safe Rent. You guys may be familiar with it. Obviously, a lot of the industry uses Safe Rent for background screening. This is pending in the District of Massachusetts right now. It was filed last year. I checked the docket this morning. It's still in the preliminary motion phase. So there's not much to report in terms of what's happened. But it was filed on behalf of two plaintiffs who were Black rental applicants who used housing vouchers to pay for part of their rent. They claim they were denied due to their Safe Rent score, which I imagine most people here are familiar with. And the allegation is that the scores result in an unlawful disparate impact against Black and Hispanic rental applicants because the algorithm used relies on certain factors that disproportionately disadvantage Black and Hispanic applicants, like credit history and non-tenancy related debt, while failing to consider the fact and use of HUD vouchers, which makes the tenants more likely to pay and more able to pay their rents. And this is obviously a major case that's facing the industry. Anybody that uses Safe Rent should be paying attention to this and mindful of it. And some of you here may have already had conversations with Safe Rent about this case. I know we've been talking to clients about sort of the impacts that it could have on them and how to deal with it and how to sort of manage it going forward and monitoring the case and things like that. And some of that's going to vary based on your relationship with Safe Rent. And it may not just be Safe Rent. There are other companies out there that may have pending lawsuits like this right now. And if not, they very well may soon, because these types of cases often reappear in copycat litigation. So I think what's important also is that the federal government filed a statement of interest here that deals with how to look at disparate impact claims under the FHA, and clarifies that FHA's case law, text and case law support the application in the residential screening process. So that's, again, really, really important. This is a case that everybody should be paying attention to. Moving on to sexual orientation and the FHA. As I mentioned earlier, there was a Supreme Court, I didn't mention the Supreme Court case, but obviously this was expanded to include gender identity and sexual orientation in 2021. That followed this 2020 Supreme Court case that occurred in the context of a Title VII discrimination claim in an employment setting, but obviously that was then used to carry over into the FHA. And I think I included this here because this was a quote from the former acting assistant secretary. She was the acting assistant secretary when I started using this quote, but she's since moved on to a different position, but made clear that housing discrimination on the basis of sexual orientation and gender identity demands urgent enforcement action. And that's why HUD under the Biden administration will fully enforce the FHA to prohibit discrimination on the basis of these two, I'll say, new protected classes, but really subsets under the sex protected class that's been around for a while. But obviously when you have this addition to the FHA interpretation, they are going to make sure that they are taking action to make clear that everybody in the industry understands that this is an area of interest at the HUD level. I included a couple cases just to sort of demonstrate. This is a 2022 case. The facts and allegations really play better when I'm not in a Zoom setting and in a conference room with management teams, and we can sort of talk about it because it's really ridiculous. But this results from a charge of discrimination that occurred down from circumstances that occurred down in Florida, where a property manager sent a letter telling the tenant that he was aware that she was transitioning and telling her to act as a man, talk as a man, and dress as a man to avoid trouble. Obviously, things you cannot say. That goes without saying. Everybody here is aware of that. I include the case, though, to note that HUD's principal deputy assistant secretary for Fair Housing and Equal Opportunity, FHEO, commented on this one in particular. And again, I think they commented on it where they don't typically do that unless they're actually filing something within the case, commented on it again because sexual orientation and gender identity is so new to the FHA world that they are taking every chance they can to make clear they're paying attention to it. So they stated in here, you'll see it in yellow, that the charge and consent order make clear that HUD will vigorously enforce the FHA to protect the rights of LGBTQIA+ individuals and ensure housing providers do not fail to meet their fair housing obligations. You can see down there was a fairly significant compensatory damages award, barred future discrimination, things like that. So that's important. Let me skip through this one because I'm trying to move on for time. I'm going to move on to emotional support and service animals here. Get questions about this all the time. Obviously, there's no protected class for emotional support and service animals, but that's implicated. There's no protected class for the animals themselves, but obviously they sort of fall under the disability umbrella, which is a protected class. And sort of where's the interplay between emotional support and service? What's the distinction? How do we deal with both? We get questions about that all the time. Service animals, let me back up. The reason for the distinction is critical because of sort of the rights and permissions that service animals get. That's a little bit different than what emotional support animals get. So service animals are trained to perform a specific task, not just providing comfort. As I mentioned, they get unlimited access to wherever their owners really need to be, including public and common use areas. And that's different than what I think the law requires of landlords and property managers with respect to emotional support animals, subject to whatever sort of reasonable accommodations may end up getting made. So that's why the distinction is so key. A lot of folks, when I do these trainings at the property level, a lot of people believe that, service animals are identified by vests, leashes, harnesses, things like that. It's not required. Really important at the property level that our teams understand that and don't make decisions or statements or comments based on a misbelief about that. We sort of go in and we talk to folks and say, look, this is not really something you can have a lot of conversations about, but there are some things you can say. Some people believe they can't say anything about it. It's important for property level individuals who are dealing with these requests to understand that they can ask two questions. One is the animal required due to a disability? And that is the sort of umbrella question that now you're, okay, we're cognizant of the potential disability issue here. We're cognizant of our obligations under the FHA. We're cognizant of making reasonable accommodations where necessary. So let's get a yes or a no to that. And then to figure out whether or not it's a service animal or emotional support, what work task is the animal trained to perform? And we can ask that because we are entitled to understand that issue. And then we stop there. We don't really go further and say, okay, well, why are they trained to perform that task? Why do you need them to do that task? That's going too far. But, if they say seeing eye dog or vision, we can distill down from that, obviously, what the disability may be. It's not something we need to talk about or should talk about, but something that we will obviously understand. So those two questions can get asked. With respect to emotional support animals, they provide, as I'm sure everybody here is aware, medical or psychological benefits to a person with a disability. What we've seen happen sometimes are somebody comes in, they fill out an application, they don't say anything about any animals in their property, they're not paying a pet deposit, and then 6 months later, somebody from the leasing office sees them walking a dog around the property. And they say, hey, I didn't know you had a puppy. What kind of dog do you have? Or, when'd you get it? Whatever. And then they go back and they realize they didn't have a pet deposit. They don't have a pet addendum. They don't have anything on the lease indicating that there's a pet in the property. And they send either a breach of lease notice or they see them the next time and they say, hey, I mentioned, I went back and took a look. Doesn't look like we have this on your lease. You're not supposed to have a pet here. And the tenant will then say at that point, oh, well, it's an emotional support animal. Can we just add it to my lease? And it's important for folks to understand that even if it's not at the beginning of the lease, they don't have to make the request at the beginning of the lease, or even if it's something as informal as a verbal request, like I just mentioned down the line, it's still a request. It's still considered a legitimate, sufficient request under the FHA, and we need to treat it as such. We can request documentation of both the disability and the disability-related need, but provided that documentation is there, even though I get the question all the time about, well, can't they just go on and print stuff out? And isn't that, doesn't that sort of undermine the whole process? It is a tricky thing, no doubt, that you all are in the position of having to deal with respect to testing the veracity of the documentation, and something that deserves a little more time and attention than we have here today. But in general, accommodations are typically going to be and should be granted if they provide sufficient documentation. The only exclusions, both here and even in the service animal context, although it doesn't come up as much, are if the animal's dangerous or poisonous, uncontrolled, creating major problems, things like that. That there have been a handful of FHA cases in the emotional support animal and pet animal context over the last couple of years. I've got 4 of them in here. Mindful of time, though, I'm going to sort of breeze through them, but you'll see this one up in Pennsylvania, and you'll see they're all United States. So it's all HUD and federal agencies that are bringing these enforcement actions. This one dealt with a strict no pets policy. Can't have it. Consent order was entered, required them to adopt a reasonable accommodation policy, publicize the policy, all things that you'd expect. Same sort of thing happened down in Kansas. HUD brought this earlier this year. HUD complainant and his son wanted to rent an apartment with a prescribed assistance animal. They denied it because the complainant's doctor did not return a form by a specific deadline. again, we can require forms for sure, but our job is to make reasonable accommodations. And if we have reason to believe that somebody is going to need that, a hard and fast deadline like this, and using it as a basis to deny housing is probably going to be looked at unfairly. We don't know the outcome of this case because it was just filed last month, but I've got my suspicions it's not going to go well for Foxmont Apartments based on the facts alleged if they're proven to be true. Here's another one in Pennsylvania that's where they went to trial last year. Jury returned a verdict in favor of the agency. Same thing. They had a no pets policy. Monetary damages were awarded in that case. And here's another one that's ongoing. Just had an award out of California recently. This one was a private action, but same sort of thing. No dogs policy, no sort of freedom or liberties granted with it. So I want to emphasize though, while these cases, many of them are no pets policy cases, even in contexts where our clients have pet policies and do allow them, there's still the potential for disparate impact claims under the FHA where the policies are unreasonably harsh or reasonable accommodations aren't being granted. So it's still something to be mindful of, even if you allow pets at your property to some degree. Moving on to familial status, FHA prohibits discrimination in housing against families with children under 18. In addition to prohibiting outright denial, it prevents housing providers from imposing any special requirements or conditions on tenants with custody of children. That's a big deal. That's where we'll see a lot of disparate impact type claims like you'll see in the next couple of cases. This one was filed last year, federal agency. The property manager or owner did not allow building access devices to minor residents, prohibited them from common areas and amenities unless supervised by adults, and misrepresented the availability of units to families with children at an apartment complex in Florida. The latter one seems fairly obvious, like you can't misrepresent the availability of housing just because somebody has children. The other two are probably less intuitive, where there can be things where you could have a policy in place that's facially neutral. You don't intend to necessarily discriminate, but the effect is, and I do these trainings, as I mentioned, with my partner Amy Earp at Beyond the Balloons. We do these for housing providing companies, and one of the examples that she likes to give is Adult Swim only. On its face, it's not intending to discriminate, or maybe arguably it could be intending to discriminate against children, but it's also discriminating against adults with children, and that's certainly unintentional because you're telling these adults that they can swim and use it, but they really can't because they got nobody to watch their kids and they want to bring their kids there. So that is, I thought of that when we see this case, and there's policies in place that don't allow minor residents building access at certain times or common area or amenity access. So that's something that folks need to be mindful of in terms of a potential FHA discrimination claim. Here's a similar one in the Eastern District of Missouri that resulted in a consent order and a $16,000 fine. The policy there was prohibiting children under 18 from accessing the computer room, on-site movie theater, fitness center, or pool without adult supervision. And you can see, and also actually ejecting that 16-year-old from the facilities and issuing a lease violation notice. But even without that, I think just the mere policy in the first section here would have the same result in the third bullet of a disparate impact or disparate treatment FHA claim that would result in a penalty and a consent order. And I think what's important about it is not the result and outcome of these cases, but the fact that these enforcement actions are being brought. That shows sort of what's happening at the federal level, what everybody is at risk of, and what everybody wants to mitigate and protect against now, so that you're not the next case example the next time somebody does a presentation like this. We are at our last slide. I know we're running long. Thank you for bearing with me. This one will be brief. Marijuana in the context of FHA. I get this question all the time, and when I'm in a different setting and we're in the conference room, I always ask for votes on this and what people think, and what, whether or not, so in light of all of the recent legislation, either legalizing for recreational use or legalizing for medicinal use, whether or not marijuana is allowed at properties and protected under the FHA. And I consistently get answers that say, yes, absolutely, you can use it for medicinal purposes, or yes, absolutely, it's recreationalized. Of course it's allowed. And then some people astutely point out that it's still illegal at the federal level, despite any sort of state laws that are recreationalized or allowing it for medicinal purposes. And therefore, it is not protected under the FHA. And there is not a lot of clear guidance right now about what to do with marijuana. The best thoughts that seem to be out there from the collective whole in the industry and lawyers within the industry is that people are treating it certainly based on where you live and what the law is in the state or jurisdiction that you're in, but generally starting to look at it as a reasonable accommodation on a case-by-case basis. That is a more detailed conversation to think about than the time we have here, but certainly something I'd encourage all of you to talk with your team about internally, to be mindful of, talk with your outside counsel if you have questions about it. But that is something that we expect to be evolving as the issues around marijuana continue to get clearer, particularly at the federal level. So we ran a little bit long. As I mentioned, I do appreciate everybody's time and attention here today. Suzanne, thank you so much for chiming in. Certainly want to open the door to anybody who may have any questions. Would be glad to answer them either right now, or we can connect offline as well. So if anybody has any questions, feel free. All right, as expected, these things rarely generate questions at the end when we do them on Zoom, but I do appreciate everybody's time. Thank you so much for giving us a few minutes. Hope you found it helpful, and I am certainly happy. Sarah's got my contact information. If anybody has any questions about anything we provided or we talked about, I'm happy to answer them offline.
Absolutely. Thanks, John, for your time today. We did record the webinar, and I have the slide deck, which I will share with everybody, as well as your contact information. So thanks everyone for being here today. Thanks for the valuable information, and we'll see you at the next one.
Thank you all.